Hello, friends. I welcome you back to my lecture series on the subject Research Methodology and Intellectual Property Rights. This subject has been introduced by Vishwesvaraya Technological University for MBA Part 1, that is Semester 2. This subject is having a 6 module units. I am discussing today the 6th unit of this, that is Intellectual Property Rights. Today is my 8th lecture series and trying to understand the TRIPS. What is the contribution of the trade-related aspects of intellectual property rights for protecting the IPR, intellectual property rights in the world? In the previous lecture series, we have already seen what is intellectual property right means, what are the different types of intellectual property rights, and also studied the origin and the various aspects relating to copyright, patents, and trademarks in the previous lecture series. Today, I'm going to discuss with you the trade-related aspect of intellectual property rights. What exactly this trade-related intellectual property rights talks about? As all of you know that when the globalization happened, right, lot of problems started arising relating to intellectual property rights when two countries started negotiating and transacting each other. When India started importing the goods from the foreign countries and started exporting to some other countries, there was an issue relating to the protecting intellectual property rights, because when we are importing the goods from the other country, the local indigenous people could have copied that technology and would have implemented in the system. And this would have been a negative impact on the exporting goods of the foreign countries. Foreign countries, with companies which are exporting to India, were trying to see that their product should not be get copied. And there is a competition and a kind of violation of certain rules. That is why at the international level, the World Trade Organization has implemented the trade related aspects of intellectual property rights to protect the interest of the several countries which are engaged in export and import as a part of WTO mission, World Trade Organization mission. Let us understand what is the TRIPS means. Trade related aspect of intellectual property rights. It is an agreement between the member countries. It is an agreement represents one of the most comprehensive multilateral agreements on intellectual property protection, fundamentally reshaping how countries approach intellectual property rights in international trade. This presentation explores TRIPS foundations, key provisions, implementation challenges, and its evolving role in the global economy. Means the basic idea of this presentation is to understand what is the TRIPS is, foundation of the TRIPS, that is trade related intellectual property rights, and key provisions implementing the challenges and its evaluation in the evolution in the global economy. Let us understand what the TRIP is. What the TRIPS, that is, it is a global information intellectual property framework. The trade-related aspects of intellectual property rights TRIPS agreement fundamentally transformed the international intellectual property landscape when it came into force on 1st January 1995 as a core component of the World Trade Organization's foundation documents. TRIPS established the first comprehensive global standards for information in intellectual property protection. That is, when the WTO start identifying there was a lot of problems when two countries are engaged into international trade, protection of the intellectual property right was a very difficult task. That is why the TRIPS was implemented by WTO on 1st January 1995, and all the member countries have signed, and they promised that the intellectual property rights will be protected at the global level. If you consider, unlike previous agreements that addressed intellectual property rights separately from trade, TRIPS explicitly linked intellectual property protection to international commerce, reflecting the growing importance of the knowledge-based assets in the global economy. Especially the difficulty was found when the international trade was done by the members of the country, World Trade Organization, that the intellectual property was not rightly protected. That is why in order to protect that, TRIPS was implemented. Before the TRIPS, at the individual country level, there were a lot of several intellectual property rights protecting within the boundaries of the country. But when the country cross borders the transactions with the other countries, globally, when it enters into, there was a difficulty in protecting the intellectual property rights of the country in the international level. Therefore, in order to protect even at the global level, the TRIPS was established and all the member countries were told to implement the Intellectual Property Right Protection Act in their country in accordance with the international standards. It should not be at the national level only. In accordance with the international standards, the intellectual properties were asked to protect. Nature of the TRIPS. If you consider the main important what you call as characteristics or nature of the TRIPS is universal application. There are 164 member countries for World Trade Organizations. Now it has crossed that also because even small countries like Myanmar and all other countries have joined recently the WTO membership. And when the member countries have entered into, the universal application of TRIPS is made, and all the members, that is 164 countries of the TRIPS, were told to follow compulsory intellectual property protection at the global level. Next, comprehensive coverage protects diverse intellectual property forms, including patents, copyrights, trademarks, geographical indications, industrial designs, and trade secrets. It means that intellectual property rights is not only protecting the designs, it is not only protecting the what you call as the patents of the one country in the other another country. It is also restricting the copyrights, trademarks, geographical indications, industrial designs, and trade secrets. All these were need to be protected. How within the country, how these were protected internationally also. Common rules were made to protect all these parts of intellectual property. What are the parts of the intellectual, different types of intellectual property? They are the patents, copyrights, trademarks, geographical indications, industrial designs, and trade secrets. All these were told to control properly. The legal litigation integration, it means that embeds intellectual property rights protection within the international trading system legal frameworks. It means that when the litigations were reported at the international level under the WTO leadership, WTO started intervening into the country to protect the intellectual property rights of the international organization within that country. Hence, WTO was empowered through this the TRIPS agreement by the member countries that WTO is empowered to deal with and try to settle the disputes arising out of intellectual property rights. So far from 1995, more than 40 cases were reported at the global level. WTO has intervened and tried to resolve the problems relating to that. Core features, standards, enforcement, and flexibility of WTO. If you see the minimum standards, what the TRIPS says, what the TRIP agreement talks about the member countries is, it builds upon existing international intellectual property conventions, incorporating the substantive provisions of the Paris Convention, that is industrial property, and Berne Convention, that is copyright, while adding a new TRIPS plus obligations. Earlier to that, industrial properties, that is designs and trade secrets, were not there, and copyright was not there at the international level. Now, when the discussion was made through TRIPS and all that, it has taken the consideration of the Paris Convention and also the Berne Convention, where all the member countries were discussed about the industrial property and the copyrights. They were also included in the TRIPS, and minimum standards was established. What is the minimum standards? Every country should follow that 20 years minimum patent protection has to be made in their own countries, and it has to be implemented even at the international level. Every member country should modify their patent tenure for the period of 20 years. When it is invented, next 20 years it has to be prepared. Except to certain national level issue the importance, in other than that, 20 years minimum period was envisaged. Next one is requires copyright protection for computer programs. Any computer programs are being developed by the computer program writers. They can copyright it, not patent it, then copyright is protected, and that copyright cannot be copied by any other person using the same kind of algorithm or same kinds of software systems. Mandate protection of undisclosed information. Any undisclosed information is there, it is mandate for the protection. If at all a company doesn't want to disclose a certain protection, it was protected by the country. No, you need not require to force them to disclose all that information. That is how this TRIPS envisages. If you see the implementation and flexibility, while establishing the minimum standards, TRIPS allows members significant di the discretion in how they implement these obligations within their legal systems. It means that certain obligations were certain freedom was given to individual countries also to modify the TRIPS at the country level. That is freedom to determine appropriate implementation method. How to implement that within the country? The procedure for that has to be decided by the company level. When it comes to international level, WTO will decide the implementations and complaints are resolved according to the WTO standards. But every country is told to establish the mechanism to control the intellectual property rights within the country. And that mechanism was led to the option of the legal framework of the countries, member countries. Internally, they can resolve their problems. The next one is compulsory licensing provisions for patents under certain conditions. It means that patents are to be given licenses. Once they're licensed, licensed version should be only used by the owners of that particular patent. That is how it is restricted in all the countries. Next one is exceptions for research, education, and public interest uses. Any kinds of that patents, copyrights are to be used for education purpose or public interest purpose, not for the commercial requirement researches. Certain relaxations were made to such kind of uses of the intellectual property rights. They were prohibited. They were what you call as given some relaxations under the TRIPS agreement, trade related intellectual property rights. Enforcement mechanism, if you look into, all the countries were guided to establish the civil judicial procedures for rights holders, criminal penalties for willful trademark, what you call as counterfeiting and copyright privacy. Any kind of a country uh, violates the rules and try to use the counterfeit products by avoiding the trademarks or intellectual property rights or copyrights. Such countries were prosecuted under the criminal acts. But complaint should be given to the WTO to intervene into that such kind of matters by between the countries. Border measures to prevent import of infringed goods. Infringed means illegal. Goods which are not prohibited to get import or export. Certain countries were prohibited to import by certain companies. Suppose if you prohibit the Pakistan to import Indian goods, then Pakistan cannot import that. If it starts importing without the knowledge of the government, without the permission, such imports from the Pakistan is considered to be a what do you call as a offense, and that is treated under the TRIPS Act. That is trade related intellectual property rights, because it is an intellectual property of the country which is broken by importing without the knowledge or without the permission of the government. Therefore, government holds certain controls over the cross borders transactions and withheld their what you call as property rights. So the next important is WTO dispute resolution system. How WTO is resolving the disputes of the intellectual property rights. It is the TRIPS enforcement is backed up by the WTO powerful dispute settlement mechanism. It means that TRIPS is backed up by WTO. WTO is a World Trade Organization which is having a control on all the members, and it has an authority to support the trade related intellectual property rights. Any country which violates will be prosecuted by the WTO by supporting the TRIPS. So what are the dispute resolution system? One is binding decisions to dispute settlement body panels and appealated body. It means that any disputes come to WTO, WTO will establish a kind of committee involving certain what you call as important countries members in that, and those members are told to resolve the problems of the disputing countries. And this mechanism, that body will have an authority to intervene, and provided if at all the punishment has to be given to any of the countries for violating that trade related intellectual property rights, even membership can be cancelled by such a standing committee which is established to resolve the problems. So it will establish a certain kind of compulsions between the countries. Any country which has violated will be penalized and will be prohibited from further violation of the trade related intellectual property rights. Next one is the authorization of the trade sanctions against non-compliance members. If at all any non-compliance members are there, it is authorized to disqualify. Over 40 TRIPS related disputes brought to the WTO since 1995. The Doha Declaration in 2001, WTO members adopted the Doha Declaration on TRIPS and public health, clarifying that what is a Doha? Doha is a place where the WTO members mingled together in 2001 and they brought certain changes to the TRIPS. The trade-related intellectual properties should not prevent the members from taking measures to protect public health. If at all any public health is at the stake and the government wanted to use certain kinds of intellectual property of the private companies, it can take certain charge under the Doha rounds. When it is the stake of the public health, the government may intervene and it can compulsorily tell the patents owners to sell the patents to the government for a particular price or for particular royalty. Next one is countries have the right to grant compulsory licenses, uh, particularly for medicines. The companies have rights to issue the licenses. If any product which is not licensed and being sold within the country, it can be prohibited by the country, especially for medicines are concerned, because some of the medicines which are outdated in one country may enter into the developing countries and may spoil the systems. In that cases, the country may take an action when it comes to public this thing. Then members can determine what constitutes the national emergency justifying the special measures. If it is a national emergency, then it can justify the measures, and the WTO, the World Trade Organization, may be asked to intervene and settle the problems. For example, when the vaccine is at the stake, when the Sputnik vaccine of Russia has been identified, and if it has to be compulsorily supplied to all the countries, the members of the countries may request WTO to intervene and tell the Russia to supply those kind of things to the needy countries. When the Russia becomes the member of WTO, being the member, will adhere to the rules and try to sell it at the very cheapest rate to protect the public health. This is how the WTO may intervene into that through the Doha Declaration, that countries may protect the national interest to a certain extent. Thank you, friends. With this discussion, I'm going to end this lecture on trade-related intellectual property rights. Question may arise in the examination. Write a short notes on the trade-related intellectual property rights. Discuss the mechanism of implementation that, or discuss the features and development of trade-related intellectual property rights. Question may be asked in the examination. Kindly prepare for the exams. Hope this video is helpful to you and may help you for your preparations. Thanks for watching the video. Thank you. See you again in the next class.